Good evening, everyone. We will begin shortly. All right. Good evening, everyone. My name is Lauren Lancaster, and I would like to welcome you all to Belly to Bump, Navigating Your Legal Rights at Work. I serve on the Birthing the Magic Advisory Council, as well as I'm the Maternal Child Health Manager for the Indiana Minority Health Coalition. This evening's webinar is sure to be an exciting one packed with great information from two outstanding attorneys, David Johnson and Anitra Brown, on ways you can navigate your legal rights. Before I get into their bios, I would like to mention that the information David and Anitra will be presenting is not legal advice. Should you need legal advice, we recommend contacting a legal professional. David Johnson is a dedicated advocate for the underserved, contributing over a decade as a teammate's mentor and serving on the boards of the Centrist Federal Credit Union and Birthing the Magic, focusing on maternal health education. He has also collaborated with the organization We Make Change to advance opportunities in technology and health information for underrepresented communities. As a Chief Compliance Officer at CSG, David oversees the company's compliance program, litigation, and human resources matters. Further, in 2022, he served as the interim Chief Diversity and Social Responsibility Officer, enhancing his role as CCO, attorney, and individual. David is also Senior Vice President and Associate General Counsel, contributing to global legal operations. His extensive background includes roles with the United States Department of Justice and the United States Department of Labor. David holds a Bachelor of Arts from Lenore Ryan College and a Juris Doctor from Creighton University School of Law. Anitra K. Brown is a three-time North Carolina super lawyer rising star with a strong law and public administration foundation. She holds a Juris Doctorate and has additional degrees, including a master's in public administration and a Bachelor of Arts in French from Grambling State University. She also earned a Master of Arts in Religious Studies, Biblical Studies, and Hebrew Language and Hebrew Bible from Howard University School of Divinity. While at Campbell Law, Ms. Brown served as the first extern to Honorable Judge Joe L. Webster, focusing on Title VII opinions. She later interned with the Equal Opportunity Office, producing a report on African American female participation in the North Carolina state government, offering diversity, equity, and inclusion solutions. Recognized for her ability to predict organizational behaviors, she excels in coaching clients strategically through the legal process. Ms. Brown's legal expertise, commitment to pro bono work, and contributions to legal innovation make her a notable figure in North Carolina's legal community. I would like to thank David and Anitra for joining us this evening. And I just have one housekeeping rule. As they're presenting, if you guys have any questions, feel free to write them in the chat box or the Q&A session. And once we break out for Q&A, we'll be sure to go through those questions. So I will go ahead and I will turn it over to Anitra. Thank you.
So much. Can you hear me okay? Wonderful. Good afternoon, evening, depending where you are in the world. It's an honor to be here. And this is such an exciting and important topic that I'm just really blessed to be a part of this conversation. I'm going to share my screen so we can jump right into the material. And let's talk about how you can navigate your legal rights at work when you are expecting to bring life into this world. Okay, and can you see my whole screen or do you see my, all right, wonderful, wonderful. Okay, like Lauren said, this is not legal advice. Please consult with a legal professional for legal advice pertaining to your specific situation. That said, knowledge is still power. So I want to be able to equip you with the type of information that can help you along your journey. Now, in the news right now, we hear this kite baby debacle, really. And it's about this family, Raleigh, Marissa, and Judah Hughes. Marissa is a young woman here, and she'd been trying to conceive um, for quite some time. Unfortunately, she lost three pregnancies in her journey. The last pregnancy actually not only resulted in the child, it almost killed her. So, in her and her husband's journey to welcome life into this world, they had an amazing opportunity to adopt young Judah. But Judah was born premature. And at just 22 weeks, he had a lot of special needs. He was in NICU. And she asked her job, Kite Baby, who literally specializes in a little swaddle cloth for babies, if she could start working from home in this transition of being with Judah in the hospital. And she was also going to need to relocate. And, it seemed like this was something that could be done. The company's response was to tell her that she only had 2 weeks. And if she wasn't back at work within 2 weeks, they were going to fire her. And her job did end in a termination. How do we prevent that? What were her rights? Particularly as somebody who had been going through pregnancies, and this particular child didn't biologically come from her, but she's very much so Judah's mother. I think if we can understand the complexity of that situation, you're going to be well equipped to navigate your situation and also be able to just know what to look out for. So, we're going to go over some information and then we're going to revisit the Hughes story at the end once we have a little bit more insight. I think we can all agree that the goal here is to welcome healthy babies and provide them with lives they deserve. That's what we really want. But we also know that things go wrong. Things can go wrong with our health. Things can go wrong with our baby's health, as you saw with Marissa. But we're also still working to provide for them. So, how do you balance those two worlds? That's what we're going to talk about today. You guys submitted questions, and one of the questions that came up is, can you provide a legal framework surrounding parental leave for birth parents? What rights and protections do they have? And that's what I want to dive into. The way I'm going to frame this legal framework is through your 5 employee needs. This applies to any employee. In particular, we're going to look at it through the lens of somebody who needs to navigate pregnancy while at work, but these are going to be your 5 needs no matter what. This is based on social science. I actually adapted this from Abraham Maslow's hierarchy of needs, and I just catered it to what we deal with in the employment realm. And there are 5 things that we need. We need pay. That's going to be the safety level, the bare minimum, making sure that we have our basic needs met. Then we're going to need policy. That's the safety. What are the parameters that are supposed to be protecting me while I'm at work? Then you're going to need partners. Every study shows that when you know that you have allies within the workplace, you're more engaged, you're happier, and you're more productive. Then you need progress. Most people want to be able to grow at work. Most people want promotion, more responsibility, and more pay. So keeping those goals of progression in mind are really important for your needs in the workplace. And lastly, purpose. I am technically a millennial, but an older one. I remember writing checks. Okay. Um, but my generation, and certainly those coming after me, are more apt to want to work at a place where they feel like their true values really align. So feeling like you have purpose and that you're really connected to the organization is really key. And that was really what was heartbreaking about the kite baby situation. It's a baby company, and if anybody was supposed to understand what Marissa was going through, it should have been that company. And that's what we're going to be facing, especially with organizations who are not in uh, the world of producing baby products. Here's a key uh, hint for you, okay? I want you to keep good records. And a little trick that I can show you is you look at those 5 employee needs, you get a binder, you get 5 dividers, And each section can be one of your employee needs. So I have a section for pay, have a section for policy, and so forth. If you keep records in those 5 categories, you will have a super binder in case something goes wrong, that you'll have, pretty much your case already put together for you to take to an attorney or the EEOC. So let's jump into it. Let's talk about your employee needs when it comes to pay. We're going to go through the law, but basically what we want to know is how can we protect our paychecks? And you're going to do that by using accommodations and avoiding termination. So pregnancy, I have found I've had many clients who are dealing with pregnancy discrimination because everything is fine until they let their employer know that they're pregnant. And that just kicks off a series of events oftentimes because employers start to think, oh, this person's not going to be here. This person is not going to be as engaged, and things can go downhill very quickly. What I want you to do in your binder is I want you to gather a few materials. This is going to create a baseline for you. This is going to let you know what your job looked like before pregnancy was part of the equation. So get your initial employment application, your offer letter, your employment contract if you have one, your job description, and a list of all your benefits. That's going to be important. You want to have all that information inside of a binder or a safe place because you're going to want to compare your treatment and your access to work benefits to before you were pregnant and then after, during and then certainly after. Okay, let's go to policy. When we talk about policy, we want to know what's keeping us safe at work. And the first place you can go is your employee handbook. But let me just say that's also our very first exhibit when it comes to court cases when things go wrong. What I found is that employee handbooks often gather dust. Great document to have, then nobody really uses it until something goes wrong. And often employers realize we didn't really do everything that we said we were going to do inside of the handbook. So let's really dive into all the sources of policy that we can reference. Legal resources, your employee handbook. It's not considered a contract per se, even if you sign that you are acknowledging that you received it. So there's been court cases that have made clear it's not necessarily considered a contract, but it is very instructive on what the employer stands for. So it's going to be a really great resource. You also want to be familiar with the federal laws, mainly laws that are administered and overseen by the Equal Employment Opportunity Commission, also known as the EEOC, and the U.S. Department of Labor, which oversees FMLA, or the Family Medical Leave Act. Those are going to be your two main federal agencies that are overseeing most of the anti-discrimination laws that we do use. State laws are also a really critical resource. Sometimes the state laws are even more protective than the federal laws. You can also reference your local health and human resource agencies. That's going to be ran through your state, and always a licensed attorney to give you accurate, up-to-date advice, particularly as it pertains to your own situation. I want you to take a look at one such resource that really gathers by topic information about the law. The EEOC actually has a really informative website. Here, if you look at the URL, that can take you directly to this enforcement guide. So we have laws that our country passes, but then we have administrative agencies who give guidance that's been reviewed similar to laws, but it becomes very persuasive in courts that this is what the EEOC has determined should be the treatment of this particular law, if that makes sense. So this is a great guide to use. Oftentimes you can just copy and paste from an enforcement guide into emails with your employer. And it's very, very instructive in how certain things should be handled. Okay. Without being incredibly dense as much as possible, I want to run through just the main laws that I believe are really at play here when we're talking about protecting you in the workplace when it comes to your pregnancy and your journey all throughout. First and foremost, Title VII of the Civil Rights Act of 1964 has kind of been our mainstay. Inside of the protected classes, race, religion, national origin, it's also sex. What's funny is that this was kind of a joke. People back in the 60s who wanted to tank the law added sex, thinking nobody would ever pass this law, and it passed. So it's kind of funny because it's really turned the tide of our country as far as women's liberation when sex was included in this law. There's been some amendments, and this has been the most protection that you've been able to get as related to sex because now it's including your the pregnancy discrimination, which is directly attributed to those who have the ability to have children. So that's been our greatest source of protection, in which case they're really looking to say you're not supposed to treat somebody differently because of their sex, because of their pregnant. So that's been our main law to, for at least ding employers, hold them accountable for treating you differently because you're pregnant. What's been incredible since last year, we have a new law on the books, also known as the Mommy Law, the Pregnant Workers Fairness Act of 2023. Now, this law is so exciting because before this moment, the only way to really get accommodations and treat pregnancy as a condition that really needed special attention was to use the law right below Pregnant Workers Fairness Act. That's the Americans with Disabilities Act. But you kind of have to stretch within the Americans with Disabilities Act, also known as the ADA, to kind of make it fit your pregnancy situation. And it was kind of tough. Sometimes there's nothing wrong per se. It's just a journey, and our bodies react differently to different stages, and it could be different for everybody. But with the Pregnant Workers Fairness Act, it recognizes not just physical conditions tied to pregnancy, but also mental conditions related to pregnancy. And that's so much more broad, and it relieves the awkwardness of trying to explain that things might be going on with me in all kind of areas because I am pregnant. So this is an incredibly exciting law. Here, it also borrows from the ADA and giving you accommodations, acknowledging that I'm going to need a little bit of help in getting around work like I was before I was pregnant. Additionally, it adds the protections. Oh, and by the way, when somebody has a condition related to their pregnancy, you cannot treat them differently. So it backs Title VII up in that way. Below it, the ADA is still there, but honestly, the Mommy Act really trumps that one as far as being the most protective for you. And lastly, I think it's most relevant is FMLA, the Family Medical Leave Act of 1993. This is the federal law that allows you to take up to 12 weeks of unpaid leave. And the main thing that it does is it saves your job. They can't replace you just because you're gone for that length of time. Now, it has some requirements. You have to have an employer that has at least 50 employees. Additionally, you needed to be at your job for at least a year and have worked for 1,250 hours. So most part-time employees would not fit the bill for FMLA. But by and large, full-time employees who are working for a mid-sized, employer can take advantage of FMLA.
Anitra, quick question. Is there a resource that you can provide that summarizes kind of all of those federal laws?
Yeah, the best place for that would be the EEOC's guidelines. And that's why I showed the web page and the chart that I have is another great resource. So I'm more than willing to share these PDFs.
Anitra, can you go back to the last slide really quickly? Lauren, it's a great question. And for those of you all that are listening and watching, This is a great list, and I would say Google is your friend, right? So once you have the names of the various laws, you can put in a little bit and you'll see that initial caption that says paid or unpaid. It'll give you some of the key details to it, and it'll give you great resources that Anitra has provided one, but there's others out there. And what I look at is the presentation materials that we provide. I recommend that you print them off or you download them to your computer or what have you. A lot of this is about planning and planning for unplanned and planning for planned. And no matter where you are in the journey, picking these up and taking a look will just help you through that journey. So, and whether that's you're pivoting to an attorney, you're trying to talk to your internal HR, whatever it may be, definitely parts and pieces Anitra is giving you helps to complete the puzzle either way you pivot. So just wanted to call that out. Lauren, it's a great question for sure.
Yeah, thank you both for that. Also, I want to do a plug for AI and also a caution for AI. If you have access to things like Chat GPT, really cool. I'm a big fan of AI, but also be careful. They are known to what's called hallucinate, which is kind of make some stuff up. So what you want to do is you do want to get your hands on someone with the more authoritative sources, like at the EEOC. And then if you are using AI, just compare those resources to make sure that what they're saying is accurate. So I'm really excited about the advancement in technology, but also some cautionary tales because, quite frankly, I've seen it make some stuff up. Moving on, we are here at the employee need of partners and what it's like to have really important relationships working with people at work. Of pregnant women, 56% work full time during pregnancy. And so having these partnerships are going to be really key.
And Anisha, we know that research says about 82% of pregnant women work going through their 9 months of pregnancy. So, do you have any advice that you can give employers and also pregnant women on accommodations that would help them through that difficult time working 9 months pregnant?
Yes, that is such a good question. Thank you so much, Lauren. Yes, this is where the Pregnant Women's Fairness Act is really going to be key because now we're talking about being at work and honestly ready to bring this life in at any given moment. And this is why partnership is so important because the interactive process is going to be the central idea of how to get these accommodations. What this means is that you and your job go back and forth in trying to figure out the best accommodation for you. One that doesn't impose what's called an undue hardship on them, which is a pretty high bar, but also something that helps you get through work as if you weren't pregnant, so to speak. It's really trying to make you whole and kind of accommodate for where you're falling short. And particularly with the Mommy Act, what's cool is that it gives the consideration of is this something that you'd be able to do within 9 months? Like you won't need an accommodation for. So that's how you know that it's going to be temporary, even though it could vary. So just some ideas, light duty. Um, so one of the things that you're going to want to do is make sure that you can still perform the essential functions of your job. But unlike the Americans with Disabilities Act, the Mommy Act does give more leeway that it's okay if you can temporarily not do something like lift 20 pounds when normally you could. So it definitely gives some leeway for that. So frequent breaks. And what happens is an employer may deny reasonable additional break times for rest, water, or bathroom use, but you can request it. And this is, again, why the interactive process is really important. A lot of these accommodations under the ADA were often refused or denied, but with the Mommy Act, These are going to be some things that you have more leeway in now. Modified schedules, ergonomic equipment, anti-fatigue mat, job reassignment. And if your employer is refusing these things, then that's how you know that they're not engaging in an interactive process. So just keep in mind these are some warnings that if they are denying the particular request, that you're entitled to them as long as they're not producing what's called an undue hardship on the employer.
Anitra, if I can jump in there for a second, is if we stay in that, is that one of the keys for me, so just to set the table, I'm representing my own views and not that of CSG. However, I want to share my experience and knowledge with you all. In essence, Anitra and I are on a different side of the dispute. In her work, she represents employees. In my work, I represent companies and corporations. One of the things that we have in common is communication is key, right? So part of this is that it's communication. Make sure you're working with your doctor. Anitra, talk a little bit, if you don't mind. Do I, as an employee, show up and say, listen, I told you I was pregnant. I want light duty. I want frequent breaks. What's the path practically that an employee might be more successful in presenting this to their employer? What are some things that they should have in hand or be thinking?
Yeah, that's a great question. Thank you so much, David. And if in-house counsel and the other side always had a David, my life would be amazing because he's really there to try to find solutions. But sometimes you're going to run into problems. Uh, One thing you have to do is you have to let your employer know that you need an accommodation. So that notice is going to be really important. You can't be in the corner fanning yourself and then yell at your employer like, how come you didn't get me, extra air conditioning? So we have to make sure that, like David said, we are communicative and saying that we do need help. Do you need a doctor's note? Well, the great thing about the Pregnancy Workers Fairness Act is that before, if the disability under the ADA wasn't obvious, it was okay for the doctor, for the employer to request some doctor's documentation because, we can't really see it. But here, even if they can't see that you're visibly pregnant, notice is enough for them to say, okay, she's pregnant, so it's pregnancy related. We're going to grant some accommodations. So that made it a lot easier. So communicating what you need is really key. Now, going to the doctor, however, would be helpful because they're going to be able to be specific about why you need certain accommodations. So just having that extra layer of support from your medical professionals is really key because I think it just alleviates a lot of questions and a lot of back and forth that would otherwise be unnecessary. So just make sure you notify your employer. It's okay to not have doctor's documentation, but I do recommend doctor's documentation to make the process easier. Thanks, David. Now let's talk about progress. We are almost done. What's great about this new act is that it supports the ability to continue roles and career progression without being sidelined. And that's really when we start talking about getting through the process, we have our accommodations, but we're also not being forced into certain roles. We're not being forced to take an accommodation. We're not told, hey, you're pregnant, you don't need to be in this meeting. That's when we start to get into disparate treatment and you're just discriminating against me because of my condition of being pregnant or my pregnancy related condition. And that's going to be a big no-no. If you were up for a promotion before being pregnant, you should be up for a promotion after. So promotional opportunities, progression opportunities should not be stifled just because you're pregnant. So if you start to see a pattern of that, that's when the employer can be held accountable for discrimination. And lastly, purpose. The act acknowledges the diverse needs of pregnant workers, allowing them to maintain their health and well-being, which is crucial for personal fulfillment and growth in the workplace. And that's really what the heart of this act is. In the materials for how the law came about, It was a specific acknowledgement that minority women, particularly Black women in this country, often lose out on purpose-filled, gratifying jobs and job security because of their pregnancies. And so just taking into consideration so many women who are valuable workers, who are educated, we're outpacing men right now in educational attainment, should also have access to really gratifying work opportunities and not be discriminated against when we are bringing life into this world. Most women, 73%, return to work within 6 months after giving birth. So it's certainly not the end of the story just because you're giving birth that your job is over. You're still working to continue your career. So those are the 5 employee needs: your pay, your policy, partners, progress, and purpose. And
Thank
when
you.
we reach No problem. I was just going to add this one thing. Raleigh, Marissa, and Judah, I hope they are in a better place and you don't have to deal with this company who really just fumbled a proper response. But what's important here with the Mommy Act, what I would do if I was her attorney, was that I would actually point out that she's probably suffering from a mental condition related to her past pregnancies and the trauma of that. And she's going to need to be accommodated for the near future. So you can come up with creative solutions using these laws. So certainly keep your documentation, do your research, and if you need to, you can reach out to a local attorney. And thank you. I really appreciate being able to be here with you guys.
Thank you, Nanisha. I actually had one question for you and David. So let's say there's an individual that's out on leave, let's call it, say it's FMLA, um, and she's being contacted by her manager regarding work-related things. Should she only be speaking to HR regarding work-related issues? Will she be denied her disability if she talks to her manager about work-related issues while she's out on leave? Is there any consequences for that action on the employer and the individual's part?
Yeah, from my understanding and the research I've done, the employer, it's been litigated that the employer can reach out in some reasonable, it has to be reasonable. Like it cannot be excessive communication. You're working every day. So it's not draconian. It's not meant to be like, don't talk to me and I won't talk to you. We're not allowed to. Hopefully that partnership is still going between the employee and the employer. And if it's something really critical, like, hey, sorry to bother you, can you just tell us where that really important file was? That's acceptable. But if you're basically working remotely while you're supposed to be on leave, that's when it gets into what we call interference under FMLA.
Thank you.
David?
Yeah, if I can, you're going to hear this a lot from me. It's communication. And so the one thing we know is that I'm likely going out in the next, fill in the number of weeks. So communication, have a conversation with your HR, your manager, and it can be, hey, if something comes up, you can contact me. And then with HR, you'd be in a position of reaching out to HR if you feel like it's excessive. Just say, hey, can you help me with this? Like, I want to help you all. I want to help my manager be successful while I'm out. However, you called me 3 times a day over the last 3 days, right? And it's just like HR is a great partner, and I like how Anitra set that up. But communication and planning, and at some point, you should take a moment, whether it's early on, as Anitra has said, or as we're getting things together for our stay in the hospital or that jump bag, as I would say, right? Is that I got to write these things down. I want to make sure I have them. And it'll be able to give you peace of mind so that you're spending time with the most important part of your life, and that's your baby at that time. So.
Well said,
Thank you.
David. Yeah, if I could add one thing, I think the whole spirit behind it and what really concerns employers is that there's going to be this huge hole, this huge gap with you being gone. They still have a business to run. So, like David said, that communication is really key and preparation. if you can set things up, leave roadmaps while you're gone, they're going to miss you, but they also won't be in this dire predicament because you're gone. So again, just working together makes all the difference.
Thank you both for your answers. I will turn it over to David.
All right, can you see my screen? Hello?
Not yet. Mm-mm.
All right, let me try it again. Share screen. And here we go. There we go.
Yes.
All right, so I talked a little bit about how basically Anitra and I are on different side of the dispute. And I think that's important. If there's a dispute that arises, we are absolutely on different sides. Until that point, we're after the same thing. What is that? Is a healthy journey, supported journey for our employee, for the employee. Because here's the thing, at the foundation of why we work, it is pay, right? And pay to be able to support your family and do the things that you want to be able to do. So we look at it, sorry, not we. The way that I want you to be able to think about this is that it is about a checklist. Anitra's provided you some of that, but with everything that you all do, that we do, we plan, right? So, hey, we know we're having a baby. What's the plan? What are the things that I should be looking at, and what are the things that I should do? So, from my perspective, here's the piece. Sorry, I don't want to make that. Hopefully, you can see it. Anitra said it, knowledge is power. So go find the things that are part of that knowledge. At any point, when you find that whether you're planning to be pregnant or to have a child, or you are pregnant, or you know, hey, we're adopting. So do you have a maternity or paternity leave policy? If you have an internal company site, you should be able to search it and find it. If not, talk to a coworker. Do you have partners within the business who you know who've been out on leave? How has it worked for you? Use the checklist and ask them the questions first. Then I hope that you're in an HR environment where HR is there to support employees as well as the company. And one of the things I learned early on, I'm very fortunate with regard to where I work. I hope most companies are like this, is that HR is there, yes, to support the goals of the company, but HR is also that bridge for our employees, for them to know how to navigate the daily work that they're in, to understand the expectations that management may or may not have communicated to them that they might not understand. HR is your key with regard to that. Now, if you don't have that partnership, I still recommend that you communicate with HR or your benefits teams. So you got the partnership, got the policy. What do I do? Read it. Does your policy even cover this situation? Right? And what are the steps I need to do to make sure I remain eligible for the benefits, for the leave, for my company? If the answer is no, Anitra gave you a nice little checklist, but within your state, just like she said, look at the leave laws within your state. What's covered? Oh, there is maternity or paternity leave. Is it paid? Right? Going back to her foundational issue, is it paid? Then what are the resources? Because what you'll find is that some of your state local agencies provide additional resources where it might not be pay, but it might be certain things that will help you in the journey. Learning, education, and the like. So then we go to HR benefits person. HR is our day-to-day person. If you have a benefits organization within or function within your company They are separate from HR, as you know. They deal with a whole list of things that they have to manage, but one of them is medical leaves, maternity leaves, paternity leaves, and these you'll find are usually individuals who really are in the business of caring. HR, the rest of us are, but they're that bridge between benefits and insurance and there to help navigate, put you in touch with the right people and the like. Uh, but you'll get to know them through this process. And one of the things I take from my mom, she oftentimes kills people with kindness, right? And as you can imagine, our HR people have a lot of employees that they deal with, our benefits people are working through various issues. You stand out with kindness, right? So take the time. Don't assume that it's going to be something negative. Look at it and give your best to make it something that's positive. I hope that will be your journey through this. And then once you get in touch with that benefits person, follow their direction and steps to a T, right? Anitra talked about documenting. It's all a process. You want to be able to get through all right, I checked that box, check that box, check that box, so you can get back to what's important. Your maternal health, paternal health, and the like, your partner, your family, so that you can move on. But definitely maintain eligibility if you have a plan that will cover you. The last thing I would say, financial planning. FSA, right? So if I've been taking out extra money for FSA, look into that, whether it's for the health, medical issues, or childcare, right? You can have some of that conversation with your benefits team, HR a little bit, but read and understand your plan relative to FSA. And then also just knowing whether your deductibles have been met. The other thing that I'm a big believer in, I like to invest in myself and my family first, 529 plans. If you have your plan, write down on it 529 plan. Your child will be given immediately birth certificate, Social Security. Set up the plan, start putting money away. 18, 20 years later, you will be able to support them in their education journey. And if they don't want to use it, you use it. Go take cooking lessons or sommelier or whatever that thing is. You can use it to be able to, I'm at the end of this career, I'd like to try this. But I'm just a big believer in that as well. And so it's overall planning. And I just want to stop there. And Anitra, anything to add with regard to the checklist, planning, as you see it when you're coming and engaging in in-house counsel or counsel that a company has hired?
Yeah, this is so great. Like I said, I just love this list. A few things that came to mind. Understanding how leave balances work with FMLA tends to be something that comes up often. You might have a bank of sick leave and annual leave that runs concurrently, meaning at the same time as FMLA. So maybe if you have 4 weeks of paid time off, they're going to use that. And so your last the last weeks of FMLA might not be paid. So just make sure you understand that, and that's where the documentation is key. Also, what came to mind, David, if you can touch on this, is the use of third-party companies who are managing FMLA requests, short-term disability requests. If you can go through and kind of give us a heads up on what could be some pitfalls and how to make that successful.
So a couple of things is that yes, companies do use third parties, and how would that work? So you might have an internal benefits or HR person, but based upon volume and the various types of leaves, companies engage a third party, and there's this handoff that occurs. And you might be told, submit your documentation through the third party. It's got its pluses and minuses, but there is an added layer of protection of health information and the like, because oftentimes companies say, okay, you're working with them, They keep me up to date, but I don't know your medical details of sorts, right? Now, one of the things that I would share with you is they're a third party. They're not the company you know. They're not the company you've been working years with. If for some reason something doesn't seem right, don't take what the third party says as the end stop be all. Go back to your HR, go back to the benefits person who you've built some relationship with and say, listen, can you help me? This doesn't seem to make sense. I'm trying to move it along. I'm trying to do the things I need to, but I think we're stuck, right? And that benefits person internally, part of their job is to get it unstuck, to make sure they understand. Because ultimately, while you might spend a short period of time with a third party, you spend a longer period of time with benefits, your fellow employee, who will navigate you through it. Anitra, it's a great question. Hope I hit the mark with what you were looking for. But again, I can't say this enough. The bridge to success is communication, communication, communication.
Yeah, that was great. You answered it right on point. Thanks.
Lauren, did you have any questions?
Yes. Yes, I had a question. So, in the age of remote work and work from home, if an employee, let's say the last month of her pregnancy, wants to do remote work, but the employer doesn't have a work from home policy, how would they navigate that space on the employer side and the employee side?
Anitra, you want to go first?
Yeah, so from an employee side, when we talk about reasonable accommodations, it already being a policy is not a thing. So it's not a requirement that something is already a policy. We can be completely creative, call it the shoe on top of our head accommodation, and be facetious here. But the point is, there really are no bounds outside of, is it an undue hardship for my employer? An undue hardship has mostly been looked at as the cost associated is astronomical, or the request completely takes you out of what your job is. So those are the two extremes that mostly are considered when we're talking about an undue hardship. Specifically, when it's coming to remote work, the interesting thing is the pandemic has shown us a lot of us can work from home. So employers are having a harder time denying that accommodation when they've shown for almost no cost, they've been able to set this employee up with working from home. So really, again, it's communication, be proactive, really lay out a plan with your employer on how you can be effective at home. And I think that goes a long way. David?
I would agree. And the pandemic has given us both sides a great exhibit, a great piece of evidence. So the opposite side of what Anitra said is that if your company required you during the pandemic to be in the office, it's a harder conversation to have because they say, listen, even during that time, right, we still had you in the office. But that it is a data point that companies have had to navigate through because all of us went through it. And we know that a lot of people were working from home. Now, what I would share in that is that what I look at is that employees can ask. From my perspective, there's got to be a reasonable basis in it, right? So how do we get there? Job description, and Nietzsche talked about that early on. You can be able to ask your HR for your job description. The other piece is that I just look at it and say, if I'm trying to line this up to be in the best possible position, so I'm going to my doctor. I hope we're going to our doctor, show the job description, and talk to the doctor about the difficulty of being in the workplace and what kind of accommodations. I think I'd be better off being able to work from home X number of weeks leading up to. The doctor will provide an assessment. Most companies have, as part of the interactive process, a form for a doctor to be able to fill out, such that we understand and we are evaluating what's the request for accommodation? And if we can't meet this, are there other accommodations that we might be able to provide as part of that process? It's a great question.
Thank you.
Do we have any others in the chat? I see something dropped in the.
Yes. Yep, we have a question from Lisa. She said it's a question for the both of you. I have two jobs, both in which I am paying for short-term disability. Both will pay for the remaining balance of what is not covered. The main thing is that I live in New York and they both require that I take New York disability before they cover the rest. Is that something that is allowed, or who should I consult to figure this predicament out?
Ooh. Anitra, I'll let you go first.
Well, certainly my recommendation is to consult a New York attorney who is well versed in New York law, particularly disability law. Just from a blanket statement, assuming that it's completely on the up and up that you have two jobs, check your work policies to make sure that you don't have to have special permission. But what I really want to draw your attention to is that what is often required for you to attest to or promise when applying for disability is slightly different than what you're applying to for FMLA, for example. So with FMLA, you have a medical condition, either a personal medical condition that makes it, impossible. You can't quite work, right? But inside of that statute allows you to kind of moonlight. Like you can technically have another job and still do stuff while you're on FMLA. But on a lot of these disability forms, you're actually attesting to that you can't do anything and you are completely disabled. So what I have seen is the disability requirements are more stringent than FMLA requirements, and you could be getting denials on the disability side because you're technically working at this other place, maybe you're going to school. So just certainly get with a local attorney who understands both of those schemes very well so that you're not checking off conflicting things on a ton of forms because you will be filling out a lot of forms.
That's great guidance. What I would share is that a couple things. Make sure you have all your documents together. Whatever you have from your employer, from your STD, what you've been able to look up with regard to the state requirements, I would get all that together and I will share the same thing that I would tell my mom, my dad, my cousin, my brother, if they ask me a question, is that you should get a well-versed attorney, right? It matters enough. There's certain things that you want to spend. Now, there's other areas where I'll say, well, I can't give you legal advice. However, this is one of those areas where I would not do that. It is important to you. Go back to the whole point of, hey, my paycheck. I need my paycheck. I need my job. And so sometimes you're going to have to invest, and that investment is through an attorney. That's where I would go. If I can, real quick, because I know we're coming up on time. I know there's some questions. I'm going to run through the next slide real quick, Lauren, if I can, as quick as
Yep, that
possible.
sounds good.
Right? Here's the actions, right? We talked about this already. Look at insurance coverage. There might be additional services in there. Your company might have an employee assistance program that offers free aspects or consultations. Call the provider. They might have some things because ultimately, insurance providers, the benefits companies that come in, and your company, we all want you to have a successful, healthy pregnancy and get back to work, right? Because we know you, we know the work that you're capable of. It's expensive to hire somebody else, right? And so the whole thing is, and we care about you, is we want you to be able to get through this, and there's just a plethora of services available. Adding child to the benefits. This is one I didn't think of, and I called a partner in benefits, and they said, hey, listen, make sure that they know and understand the requirements prior to birth. There might be time constraints and the like. And I was like, wow, that's a really good one. Leave plan. How do you want to use it? Your spouse or partner might have a leave plan at their work. How do you want to bridge it? Do you want to take 2 weeks? They take 3 weeks. You take 2 weeks. Coordinate it. and then talk to your manager, HR. So everybody's on the same page. You might do a little bit of negotiation. I'd like to not use that word, but conversation about what works best for the both of you with your health and care in mind, but plan for that as much as you can. The other thing is following the requirements. You can see this here, but there's just specific things. Hospitals help with birth certificates, Social Security. It's been a while since I've been through that process, but that was another thing that a benefits partner told me about. So there's a lot of support to it. You're not alone. The internet is your friend, and you're not on an island. I can't say that enough, but communication is key. So I'm going to bring that to a close. I know we're coming up on the hour. Lauren, it's up to you on the questions we might have, and I
Yep.
will stop sharing.
All right. We have two questions in the chat box. Sharita asks, my job is putting my disability start date at an earlier date than when my doctor put me on leave. This will make me have to return to work sooner than I want to. What should I do?
Yeah, so we can assume positive intentions. Maybe it's just an oversight. Okay. Because you have that great binder I told you to put together, you have all of your documentation laid out. Verify that the date that they actually have you out, you were at work. Maybe if you have emails, any kind of documentation showing that you were in fact at work, simply approach HR and point out this miscommunication or misunderstanding. It looks like they inadvertently put the wrong date. Would they mind correcting it? Mm. And if that doesn't work, might need to call an attorney. Continue to go on leave. Don't stress about it. Excuse me. One thing I do want to make sure, if you're on leave, you can get into these paperwork battles that completely zap your leave and you're more stressed out than when you left. So at some point, you need to just gather the documentation, send a reasonable email, and then just have boundaries. If it comes back to bite you at the end, at least you have all your documentation. So when it's time to get an attorney involved, you have some backup.
Sorry, it's been back and forth, right? Clearly, if you've been going back and forth, it's not a good circumstance. And what I say is bang your head against the wall once, maybe twice, and then Anitra gave a great point. Focus on what you need to focus on, but have some information handy so that you can go get some guidance and advice. I think there's one more, Lauren, and definitely good luck to you in the journey.
Yes, we have
Um,
a question from Natasha. She says, can you discuss a bit about reasonable accommodations for nursing/pumping and what that can look like? Is it limited to private space? And then can telework be considered?
Oh yeah, great question. David, did you have something on that?
just real quick, I can remember where companies weren't even providing a private space, right? And so it's a great place where we're at, where it's private space right? And so what I would share is when you say telework, I think a little bit what the challenge is that I want to be able to work from home during the period that I'm pumping, right? And what the employer would say is that, so a couple things that I would talk about is that it depends on your particular circumstance and situation, right? Every situation, every person is not the same. Now, you're going to articulate your situation through, I would start with your benefits, your HR person. Your manager doesn't have to understand all the details. HR, this is when HR is a great bridge, right? Now, if you think you got a manager who might understand and you're able to work through this process, absolutely. But I would say companies aren't required to meet just one type of accommodation or provide one. It is an interactive process. And so engage with them during that. And yes, there are times where we get into a dispute because there's a preference over one over the other. Anitra?
Yeah, David's absolutely right. First, when it comes to pumping, is the newer law called is the Pump Act that was passed last year. Every employer is required for covered employees. So these are employers who have 50 people or more. If they have more than 50 employees, they are subject to the Fair Labor Standards Act. And an extension of FOLSA is actually the Pump Act, which says there has to be a private space. It can't be a bathroom that allows for mothers to pump, and you have to allow for a reasonable amount of time for them to do that. So enough breaks where that's reasonable. Additionally, the mother can take advantage of that for up to 1 year after the baby's been born. So what you could do here is number one, make sure they have the space, because if not, they're in violation of this act. If they don't, you're like, I'm not trying to blow whistles. It's not that serious. Let's talk about an accommodation where I can work from home. You don't have to create a new space for me, but I'm going to work from home. I think if you bring that to their attention, they can work on getting that private space, and you can also have what you need.
Thank you both for those answers. So in the essence of time, I will kind of call for any final questions that anybody might have. I'll give it a couple seconds here.
You
And
guys are
Natasha says
so
very
welcome. Thank
helpful.
you for a question. Yeah,
All right, so
we
on
love
the
this
behalf
kind of
of
stuff.
on behalf of Birthing the Magic, we would like to thank you all for attending Belly to Bump, navigating your legal rights at work. We invite you to join us tomorrow for our mindful birthing workshop that's starting at noon Eastern, 11 a.m. Central, and 9 a.m. Pacific. And you can learn more about that on birthingmagic.org. Also, follow us on Instagram to keep abreast of any upcoming program that we might have, and visit our YouTube channel. And thank you all and have a good night.
Good night.
Take care.